Judgment in the matter of Iceland Foods Limited versus Berry Valuation Officer.
Lord Carnworth will explain the decision of the court.
Iceland Foods is a well-known supermarket operator specialising in refrigerated goods. Its premises include a retail warehouse at Penketh Drive, Liverpool. The issue in the appeal is whether a specialised air handling system used to maintain the temperature needed for the display of such goods is to be excluded from the valuation of the premises, or hereditament, for rating purposes. This turns on whether the system is used as part of, quote, manufacturing operations or trade processes within the meaning of the Valuation for Rating Plant and Machinery England Regulations 2000. The issue was decided in Iceland's favour by the Valuation Tribunal, but the Upper Tribunal and the Court of Appeal took a different view. The Supreme Court now unanimously allows Iceland's appeal. The judgment is given by myself, agreed by the remainder of the court. The reasons, in short, are these. The 2000 regulations were derived from recommendations of a report by a committee under the chairmanship of Mr. Derek Wood, QC, published in 1993. His proposals were designed to improve and harmonise the law across the United Kingdom. The report reviewed the history, which showed the difficulty of drawing a defensible line between plant properly treated as part of the hereditament, such as ordinary lifts or air conditioning, and plant or machinery more fairly attributable to the tenant's business within it, in other words, the tools of his trade. The Wood report accepted the validity of a tools of the trade exemption, but thought that it should be subject to various qualifications in the interests of fairness between ratepayers. It recommended preparation of new regulations to remove the ambiguities and difficulties of the previous versions. The 2000 regulations were, as the explanatory notes make clear, designed to give effect to the Wood recommendations. The relevant regulation in this case excludes from valuation plant or machinery on the hereditament, which is, quotes, used in connection with services mainly or exclusively as part of manufacturing operations or trade processes. It is now common ground that if the air handling system is used as part of such trade processes, the wholly or mainly test is satisfied. The Supreme Court rejects a valuation officer's broader argument, not advanced below, that this exemption is concerned only with productive activities in industry rather than other trade activities. This restrictive view is unsupported by anything in the wording of the regulations or the Wood report. The Court also rejects the view of the Court of Appeal and the Upper Tribunal that the exemption should be construed narrowly as concerned only with processes designed to bring about a, quote, transition from one state to another. That is unsupported by the purpose of the exemption in the statutory scheme. Nor is there anything in the word process itself which implies a need for a transition or change. It can, in ordinary language, be read as including anything done to goods and materials. There is nothing in the context to require the meaning to be limited. A trade process is simply a process, in that sense, carried on for the purposes of a trade. In the present case, it is apt to cover the continuous freezing or refrigeration of goods to preserve them artificially for the purposes of Iceland's trade.
Thank you very much indeed. The court will now adjourn.